This video is going to take a look at the investigation, the evidence as we know it to be so far, and as presented by the court, and we are going to ask some serious questions about how forthcoming spokespersons for the investigation and even information about this case as presented by the Idaho court has been with us, public. And the answers we will arrive at may be shocking to some of you.
The facts of the case that we know right now.
There's possible misconduct.
The University of Idaho, our community, our country, and our officers.
We've been working with Moscow Police since we were notified on Sunday of the crime. We've helped when asked and continually push for information whenever possible, knowing that we cannot interfere with the important work and good investigations.
Confidential internal affairs investigation.
Welcome back to What's the Obsession, covering the state versus Bryan Kohberger. Let's go back to the beginning and look at something rather curious that have been told to us as the public. First, let's take a look at one of the recent court filings. Bryan Kohberger's lawyers want to make public their requests and arguments for dismissing charges. In the capital murder case that has been marked by secrecy and media restrictions, the attorneys for Bryan Kohberger request that the Honorable Judge make public their request for him to rethink his previously made and reinforced decision not to dismiss the indictments. Once again, I think we are seeing evidence of the defense's understanding of the power of public persuasion. Arguments on Kohberger's request for the judge to toss out his previous ruling that the indictment will stand are scheduled to be heard on January 26, 2024. Now, we tend to take these pre-trial proceedings very seriously, the motions and the responses and the judgments made by judge, because after all, in the midst of this overly broad and strict gag order, the information that we glean is very sparse, and we would like to believe that the information that we learn through the court orders and motions is fact. It is legitimate. It is evidence. But can we rely on those assumptions? This video is going to raise serious questions about the reliability and accuracy of the information we are receiving through the court filing and the investigation itself. Now, before going forward in this video, I need to give credit to the YouTube channel, The Interview Room, with Chris McDonough and his wife, Karen. If it were not for the work that Chris McDonough and his wife, Karen, did and revealed in a recent episode of The Interview Room that I will link in the description, I would not have been confident enough to report on this information and some of the hunches that I myself have had and have discussed with some of you. So please, everybody go check out The Interview Room with Chris McDonough. He is a retired homicide detective and his channel is amazing. Oh, and by the way, continuing my credit to that channel and little plug for that channel, his wife Karen is a former investigative journalist. I want to pick back on something that I mentioned earlier, and this is not something that was talked about in The Interview Room, although I bet that they are aware of this element. Defense team and the way that I believe that they work the public and understand the power of public persuasion. After all, it is the public in Idaho that the jury for the trial will be selected from, and those 9 individuals plus alternatives will be holding all of the fate for Bryan Kohberger mostly, and also the defense team's careers in their hands. And also, there's a gigantic issue of justice at hand. In regards to the death penalty and the strength of the state's case. And I do believe this is the situation in this particular case. Although I definitely wouldn't want to grow too confident if I were the state, that once prosecution puts the death penalty on the table, that indicates that they have a very, very strong case. And historically, when we look at death penalty cases, we can see that almost always across the board, this is true. Death penalty on the table, state has a very strong case. That being said, when you are the defense team in a death penalty case, it is said that your game is all about mitigation. You are trying to mitigate the aggravating circumstances of the egregious crime that occurred, basically, so you can get the death penalty off the table, or you can ensure that you've got your hooks into an appellate issue. So that's how we might expect the defense to act in typical circumstances, if there are any, in a death penalty case. But this defense team in particular, I think, is certainly playing that mitigation game, and they're being good, responsible attorneys, and they're doing everything that they can to defend their client because these are very, very serious charges, and his life is on the line. Above and beyond that, I think that this defense team has a very clear sense of what's up with this case. With everything that has happened from the very first moments of the investigation to how things are being handled in court, from the first judge that initially saw Bryan Kohberger to Judge who is sitting at the bench at this time. Now, I will confess that I did not always see things this way. But luckily, my opinion is nothing more than my opinion. As we learn more and hear from more experts, my thoughts on some things are evolving. But what I want to know is what you think. Has your opinion changed on some of the fundamental aspects of this case investigation began? Leave a comment below and let us know what your experience is with that. As time moves along, I believe that the defense has a very good idea of the game that is being played, that was being played by law enforcement and their partners, so to speak, by the court, which really is kind of such a sad thing since courts are our administrators of justice and we rely on them for that in our society. But let me explain and back up just a little bit. Months and months ago, way back in March, and even before that, but I can point to a very specific motion when the defense filed the motion to compel Bethany Funk's testimony at the pre-trial hearing way back in March. Now, it wasn't Ann Taylor who wrote the body of that motion. Ann Taylor, in that case, hired somebody special on her team who wrote that motion and spoke with his voice in that motion, saying that Bethany Funk must come forth and testify in the pretrial hearing because she is a material witness, because she is in possession of exculpatory evidence, and her experience is hers alone. It's unique. We must hear it. This is mandatory. It's super important to the case. It has to be done right now before the trial even begins. Now, I've explained before that I do not believe that the defense ever thought that Bethany Funk was in possession of true exculpatory evidence. I've also told you what I believe her experience to be based on the insider information that the channel received from our two friends, the two guys at the University of Idaho who were friends with the victims and believe that they well know what her experience was, but that's a different topic. I believe that the defense filed that motion to compel Bethany Funk's testimony at the pretrial hearing just to get the public's ears perked up. And also because I think that they knew that Bethany Funk's testimony was going to be their great big wild card in the trial. And before they could put forth their alibi, which at that time was already late as far as the court procedure timeline, they needed to know what Bethany Funk was going to testify to before They put forth a theory of alibi that was going to be in direct conflict with what, for all they knew, could be a really solid testimony from Bethany Funk, putting the blame squarely on Bryan Kohberger. I believe that what Bryan Kohberger's defense is doing right now in trying to get a lot of the trial information and orders and motions and evidence unsealed is very similar to what they were doing when they filed the motion to compel Bethany Funk's testimony at the pre-trial hearing. They understand that powers that be, the investigators and their partners, and even the court are both hiding things from the public and they are trying to make certain things seem like something other than what they really are. Now, I personally still lean towards Bryan Kohberger most likely being guilty, although I am not at all married to that idea. And if evidence shows me otherwise, I will sway in the other direction as soon as I see that evidence. But I don't think that the defense wants all of these documents unsealed or unredacted because there is some value in those documents towards Bryan Kohberger's actual defense. I think what the defense really wants is for all of the people all over the world who are paying attention to this case, even in the pretrial phase, to see what happens when things start becoming unsealed or unredacted and nothing is like the public believed it to be. And oh my gosh, the shock and awe in that movement in general is going to move momentum towards for Bryan Kohberger and the defense's efforts and away from any pro prosecution leaning that's out there. Okay, so let's get back to the issue that is the reason I brought the channel, the interview room, into this video. And where we're going here really gets down to the core of the issue of cover up, deception, obfuscation, and possible wrongdoing. I don't know. You'll have to let us know what you think. I bet that you have heard or been part of a conversation about that document that we've been calling the probable cause affidavit that was so long and so detailed, touching on so many different topics. It is a document where it's going to go down in trial record history because when it first came out, many of the details were so shocking to all of us. For those who have been following this case at all, it's the document that I'll read through a million times, and countless people have commented on and how unredacted that document was. I've commented so many times during live streams and in videos about the level of unredaction in that document, and always thought it was a rather curious point, along with identifying some other curious points within that parent affidavit. But what if I told you that the PCA or probable cause affidavit that we have believed we were reading all along is not really the probable cause affidavit? It was the affidavit submitted to the court for the judge to sign for a warrant for the arrest of Bryan Kohberger and the search of his property. That's right. Have we really even seen probable cause affidavit? Well, I believe the answer is no. I had always wondered why the document that we were calling the probable cause affidavit was listed as Exhibit A, statement from Brett Payne. And there was also another Exhibit A released at the same time that was much harder to find, at least on the internet or any court document source, is Exhibit A, a statement from Dustin Laker. In fact, early on, when I was looking for this resource, it caused me a lot of confusion when I was just doing a basic Google search of it. And why is that? Because a PCA is usually labeled as a PCA, a probable cause affidavit, not an exhibit A, B, C, or D. So here is an example of a probable cause affidavit from the state of Idaho. It's in with one of those Idaho cases of interest, where we can find all of our court documents for the State versus Kohberger case. And you can see on this form, it's called a probable cause declaration. And it says that the detective declares under penalty of perjury and the law of the state of Idaho that the following statements are true and correct: that this person is a deputy asserting who he is, and that the following sets forth the basis for probable cause for an arrest, bonding the named defendant of the crimes, and then it very specifically lists the crimes. This is typical of a probable cause affidavit in the state of Idaho. Now, just so we can be clear on things together, let's go over the two kinds of arrests that might happen and where probable cause comes into each of those types of arrest procedurally. So there might be a warrantless arrest or an arrest with a warrant. So in the case of Bryan Kohberger, he was arrested with an arrest warrant, meaning a judge signed a warrant for Bryan Kohberger's arrest after the probable cause declaration or affidavit was submitted to the court, establishing that there was indeed probable cause, United States, Idaho law, to arrest Bryan Kohberger in connection with the crimes for which the warrant was sought out, which in this case is 4 counts of first-degree homicide and 1 count of burglary. In this case, where there is an arrest with a warrant, the probable cause declaration or affidavit precedes the actual arrest. So, in this case, a police officer clearly knows that a horrible crime has been committed. So, the police officer outlines probable cause affidavit or statement that gives legal justification for the police officer to make an arrest. This is using the reasonable person standard. So essentially, if the situation presents itself where a reasonable person would believe that that particular suspect has committed the crime that is cited, then the police officer is justified in making the request for the warrant. If the judge agrees that the police officer is justified in needing that arrest warrant, they sign the warrant, and the warrant is live, and the suspect is then taken into custody with an arrest warrant in hand. Somebody may also be arrested as a warrantless arrest. Every time a person is arrested, there is not a warrant that is sought out and obtained beforehand. This can play out in a number of scenarios. Think, for example, of the Chris Watts case. There was a crime that was committed. The atrocities of the crime were unfolding. During the process, Chris Watts being interviewed, certain levels of a confession came forth and the facts came together at some point during the questioning of Chris Watts that gave the officers of the law probable cause to believe that Chris Watts committed the crime or crimes, and he was arrested without probable cause affidavit because the situation was still unfolding. In this case, there will be a probable cause hearing after the arrest. We then enter into the PreTrial Phase of criminal procedure. And in this case, there will be a probable cause hearing after the arrest is made. A judge will determine if there was, in fact, probable cause for the arrest. And if the judge determines there was probable cause for the arrest, the charges that were the basis for the arrest will hold. In this case, with the case of Bryan Kohberger's arrest, we know that there was an arrest warrant because it is right here. But we do not see the probable cause affidavit or probable cause declaration per se. What we do see is this Exhibit A by Brett Payne, which is not labeled a probable cause affidavit or declaration. As I mentioned before, many have marveled at the fact at how highly unredacted this, what we believe to be a probable cause affidavit, was. But now we need to ask the question, and maybe some of you already have we even really seen probable cause affidavit? towards the arrest of Bryan Kohberger? Well, so then there is also this from March 7th, 2023. This is one of the motions or orders to have some of the evidence sealed. In this case, it is a company called Extreme Network. Okay, so on this documentation, there are some statements at the very end of the document, and you can look at 1, 2, 3 at the bottom of the page of this document. Number 1 says the affidavit in support of a search warrant is sealed. Now, I think we need to get very specific here on the wording so we can come to agreement on some of these terms. So the exact wording is affidavit in support of search warrant is sealed. No, it does not say the PCA is sealed, but it's important to understand. Here's how the two are connected. In order to obtain a search warrant, a probable cause affidavit is clearly going to be stating the probable cause to believe the suspect committed a crime and defining the crime precisely. Without that, no search warrant. The probable cause affidavit is also going to specifically outline the exact charges. It will say something like, and that the suspect is going to be charged with X crime, and therefore a search warrant within this scope of searching these specific things must be done in order to get the evidence needed to eventually support the charges and, take it to trial or whatever is going to happen. So essentially, and yes, What's the Obsession legal counsel was absolutely consulted on this one. Probable cause affidavit and the affidavit in support of search warrant are essentially one and the same. And again, let me read this statement on this order to seal some evidence. It says, number 1 here at the bottom of the page, the affidavit in support of search warrant is sealed. My friends, we have not actually seen or read or heard being read the probable cause affidavit towards the arrest of Bryan Kohberger. We have not. So that leads us to another question. If the document we've been calling the probable cause affidavit, the Exhibit A, the statement from Brett Payne, is not really the probable cause affidavit, then how much can we truly rely on the information contained within that document? I know that I've discussed on this channel before, after speaking with the What's the Obsession legal consultants who really know their thing, that they have reported that probable cause affidavit better be damn tight. If it is found later on to not be factually accurate, charges can be thrown out altogether, and it's just obviously not professional or sound in establishing those first steps in getting a suspect into the judicial system so justice can be served. Well, there are indeed some issues, and guess what? I'm going to tell you about them. The first issue we have is with Officer Brett Payne. Now, the issue I'm about to bring up is not necessarily a new issue. Maybe it is to some of you, so I'm just going to explain it very briefly. In this document, the Exhibit A, it is stated that Officer Brett Payne has 4 years experience on the Moscow Police Department. But we know that that is not actually true. That is a lie, a falsehood, something that is definitely less than accurate in this probable cause affidavit or Exhibit A, or what is this? So who is Brett Payne anyhow? Well, this issue of Brett Payne not even having 4 years in the Moscow Police Department and being a total rookie was brought up by Shannon Gray, the attorney for the Gonsalves family, a while back. And this is what was said about that at this time. Shannon Gray says, when we went into a meeting on Monday, Brett Payne is the individual who identified himself as the lead investigator on the Moscow Police Department. My understanding is that he was hired in 2020 as a rookie. He has a total of 2 years experience. I sent an email over to the Moscow Police Department asking them to send some credentials over for some experience or some education for that office that Officer Payne might have. It would give us some confidence. And their response was, quote, "It's personal records, and we are not privy to that." So who the heck is Brett Payne anyway? Payne reportedly served in the 82nd Airborne Division in Afghanistan before joining the Moscow Police Department. Brett Payne joined the Moscow Police Force in 2020, and that is confirmed. It's April of 2020 to be exact. And it was his first policing job. He was awarded the Rookie of the Year award. The department praised Payne in its annual report for that year, saying, quote, "Officer Brett Payne was awarded with the Champs Rookie of the Year award. Officer Payne brings a great deal of experience to the Moscow Police Department because of his military service. Officer Payne was the first officer in post history to be awarded 3 post awards at the Academy. His approach to community policing is exemplary. He has a desire to serve and protect the community. In addition, he regularly takes time away from his own tasks to help his coworkers, especially new officers. Whether it's citizens or other officers, Brett Payne is always willing to put his needs aside to assist others. He exemplifies the core values of our department and is an excellent example to other officers." Well, isn't that just peachy? He sounds like a really great guy, a really great leader, maybe a really great example for young, struggling students, perhaps. But does that qualify him as being the lead investigator on a quadruple homicide with a police department who is not at all used to those kinds of crimes? It definitely doesn't. Now, clearly, we have the Idaho State Police also involved in the investigation. We have the FBI also involved in the investigation. But I think that we do have to question, and this is nothing disparaging towards Brett Payne, but why the heck did the Moscow Police Department and Chief James Fry appoint him as the lead investigator? It does not make sense. Okay, my friends. So, as we explore this question of have we even really seen the PCA or the PCA as opposed to Exhibit A, we certainly cannot ignore the fact that Exhibit A is made up of 2 pieces. There is Exhibit A, the statement from Brett Payne, and Exhibit A is statement from Sergeant Dustin Blaker. Okay, so I'm just going to go ahead and read the first part of the statement from Sergeant Dustin Blaker, Exhibit A, or is it A sub B? I don't know. The below information is provided by Sergeant Dustin Blaker. I am a duly appointed, qualified, and acting peace officer within the county of Letah, state of Idaho. I'm employed by the Moscow Police Department, MPD, in the official capacity or position of sergeant, and I have been a trained and qualified peace officer for approximately 22 years. I attended the Idaho Peace Officers Academy from January 2000 to March of 2000, and then completed a 16-week field training program where I was released in July of 2000, turn of the millennium. During my 16 years of law enforcement, I have attended additional trainings, including basic narcotics training, in which trained me in handling high level cases. I've conducted many search warrants and I've assisted with previous homicide investigations while at the Moscow Police Department. I am being assisted by other officers of the Moscow Police Department, members of the Idaho State Police, and agents of the Federal Bureau of Investigation. Let's now look at the 2 Exhibit A's, the Exhibit A statement from Brett Payne and Exhibit A statement from Sergeant Dustin Blaker, and look at the differences between the 2 statements. Well, clearly, there is a large difference in their experience level. Brett Payne stating he has approximately 4 years as a peace officer, but we know that 2.5 years, it's going to be up to you whether you think that's a big deal or not. And then we have Sergeant Dustin Blaker, who has served for 22 years. There are two more major discrepancies we can see between the two statements. One is having to do with the whereabouts of Ethan Chapin and Xander Kernodle on the evening in question. In Sergeant Dustin Blaker's statement, he can account for them in, that 8 to 9 o'clock hour when they were apparently known to be at the Sigma Chi house, and doesn't say anything about after 9 p.m. Then Brett Payne's statement gives us a lot more information about their apparent whereabouts, accounting for their whereabouts all the way up to 1:45 a.m. That's a really big time difference. Another notable and perhaps more problematic difference between the two statements has to do with the most important evidence in the case. Brett Payne's statement talks about the knife sheath as being an item that he, first person, spotted, located, found perhaps when he walked into the room. And Sergeant Dustin Blaker's statement says that that knife sheath had been found by the Idaho State Police. From Brett Payne's statement here, as I entered this room, I could see two females in the single bed in the room. Both Gonsalves and Mogan were deceased with visible wounds. I also later noticed what appeared to be a tan leather knife sheath laying on the bed next to Mogan's right side when viewed from the door. And then it goes on to describe the knife sheath. Now, Sergeant Dustin Blaker's statement reads like this. As I entered this room, I could see two females in a single bed in the room. Both Gonsalves and Mogan were deceased with visible stab wounds. I was later advised by the Idaho State Police investigators. They located a tan leather knife sheath laying on the bed next to Mogan's right side when viewed from the door, and then he goes on to describe the knife sheath. So, where these discrepancies lie between the two Exhibit A's, the two statements from the two different authors, do these issues matter? Well, certainly they do, particularly if I'm the defense or, hey, well, if I'm the state as well. Don't we want to know exactly who found the knife sheath that had probably the most critical piece of evidence on it? And yes, this might come forth in trial. The probable cause affidavit was never meant to tell us everything anyhow, but questions still exist. And would we want to know where Ethan and Xana were? Well, especially for the defense, in terms of an alternate theory or an alternate suspect theory, yes, absolutely. As the defense is trying to draw attention away from the prospect of their suspect being guilty, they are pointing towards everyone else's whereabouts. Certainly, all of the victims in this tragic case. They would absolutely want to make a very specific and strong point about what they were all up to that evening. Now, today's video just started to touch upon the issues that we can dive right into when we ask the question, the legitimate question, have we even seen a probable cause affidavit? There is so much more to cover, all lined up for you. It's going to come out in a part 2 video sometime in the next few days because, guys, this video is just getting too long for our attention span, 33 minutes, but I really appreciate you watching. I would love to hear what you think about the issues that were discussed in this video. It's a conversation, and your part in the conversation is so important to the entire discussion and to this channel. Thank you so much for everything you contribute. And as always, let's remember the victims and their families. Madison Mogan, Haley Gonsalves, Ethan Chapin, and Xana Kernodle, and all of their family members. We are moving towards justice for those victims, and we pray every day that those family members find a greater sense of peace.